I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. For number 262, this is going to be our celebrity edition. We have had a few different people on the channel that have become celebrities in their own way, whether that's through singing, acting, whether that's from being a judge on the bench and having an incident, or being a cop in the courtroom. So we're in 4 different courtrooms on today. Once again, we have a singer, an actor, a judge, and a police officer. And for the police officer, it's a non-sov sit, but I think you guys are going to enjoy it. Before I give you those judges' courtrooms that we will be in, don't forget to like, comment, share, and subscribe. It is always appreciated. Commentary will be left in if there were any commentary, and chapters will be added for your convenience. Now, let us get into the courtrooms that we will be in on today. First, we will be in the courtroom of Judge Simpson out of the state of Michigan. Second, we will be in the courtroom of SanDiego Superior Court. Third, we will be in the courtroom of Judge Kenneth King, also out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Sean Perkins, also out of the state of Michigan. Like I said, these 4 different individuals that are highlighted in these particular proceedings, they have become celebrities in their own ways. I'm sure you guys are going to enjoy it. And you can also just Google their names and see exactly what happened with the stories, get some backstory on it, watch some news footage, whatever have you. But listen, let's go ahead and jump into 262.
Court calls case People versus Jade Latham.
Case on behalf of the people.
Overwater Assistant Public Defender on behalf of Ms. Lathan. Ma'am, would you state your name for the record, please?
I'm not Ms. Lathan, I'm principal. I am J. Ruth Bay, card holder and principal of Jade Lathan.
Your Honor, I did attempt.
Mr. Overwater, while she's given that, is this the person that you know to be the individual named in the complaint? If not, we are going to have a problem, and I will have this person, since she got up here, taken into custody. We will do fingerprints and we will determine her identity by our standards. So we can do it one of 2 ways.
Judge, I don't question that she is physically the person that is alleged to have committed these offenses. What I do believe is that there is an issue as to competency.
For the record, I do not know this man, and I did send him a cease and desist to not represent me. However, thank you, Your Honor. I am the principal and card holder of Jade, Ruth, and Lathan, and beneficiary.
Very well. Mr. Overwater, you are on this case, so what do you wish?
Judge, I believe that at this point, the issue of competency needs to be raised. So I would ask for a competency evaluation. This matter be set over for a competency hearing.
I'm not
pursuant
asking
to the
for
statute.
anything, and that's, I mean, from the horse's mouth.
I'll need an order.
I did turn in my statement of fact so that there's more than the police record on the record. I have not harmed anyone, and the cameras will reflect that if we are to go that far. But I would like to motion to settle.
I don't know what that means.
Well, I want to settle because I'm the card holder in X relation to the principal, and I do not want to be
I have
mistaken.
no idea what you're talking about.
Okay, I yield.
Thank you. Forensic evaluation is ordered. I'll order a competency hearing. I'll set that competency hearing for 90.
June 6th at 9 a.m.
June 6th, 2024, 9 a.m.
2020.
At this time, bond will continue. Mr. Overwater, prepare the order, please.
I will do that, Your Honor. Thank you.
Thank you.
Thank you, Your Honor.
Court calls case People versus Jade Lathan.
Mr. Kenneth for the people.
Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lathan, who's approaching. Ms. Lathan, would you state your name for the record, please?
J. Ruth Bay, beneficiary of the principal.
Your Honor, I have spoken with Ms. Lathan several times. We've reviewed some of the discovery. We are looking into some potential resolutions. I'd ask to adjourn the probable cause conference. I would ask for more than 2 weeks.
August 29th, 2024, 9 a.m. Continued. Thank you.
Thank you, Your Honor.
Case People versus Jade Lathan.
Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lathan, who is approaching.
Your name, ma'am?
I'm J. Ruth Bay, the nationality of Moorish American, beneficiary of the principal Jade Lathan, and I'm making this special appearance at District 15, Michigan Court of Law under threat, duress, and coercion. I'm asking the prosecutor to dismiss this case on the grounds that there is no injured party. Plus, I have the right to a speedy trial, and this is the 5th time I've made an appearance for this in the case in the court of law since February 2024 for the arraignment. Since the arraignment, when the Ann Arbor Police Department apprehended me unlawfully and kidnapped me, forcing me to take fingerprinting and a mugshot when I am not a criminal. Officers Morgan Parker 15400 and AA Condolis 02002 claimed I fit a so-called description and also violently attacked me and produced a false police report against my person. These officers falsely accused me of committing crimes that the tapes do not show me doing at all. These tapes do not show me doing at all any of the things that I'm being accused of, as I've never harmed another person in my life and certainly not an officer of the law. I've disturbed the peace, and I have on file with public defender Kenneth Overwater right here to my left, a character letter from my former teacher proving that I've always been a well-behaved student, and have always gotten good grades and have no history of foul play or violence, which is still true to this day. My legal representation on the day of the arraignment on February 2024, who helped grant me my freedom on bond, has already stated on the record that I have no history of violent offenses, which is the truth. And I assume why I was granted my freedom from police custody. I would lastly like to say that on March 11, 2024, I was denied 2 main sources of evidence for my case via my personal FOIA request that would have easily shown my innocence. These 2 things are the mobile gas station cameras, and that will show the young boy already on the phone when I walked into the gas station. But either way, I was not at all acting out of the ordinary or belligerent. I was nothing but kind to everyone in that store. And I'm nothing but peaceful, and I'm saddened that I have been accused of behaviors that are not true. And I would like to exclaim that I'm a victim of a false 911 police call when I had no idea I only know that because of the police report that I got after the fact. I humbly ask both the prosecutor and the judge that this case be dismissed because I have school and I have church to attend, and my college studies have already began on August 26th at the community college. And I'm asking you to grant me my justice from this, taking up my time, because my time is very valuable to my community and I would once again like to motion to settle this case for full dismissal in a speedy manner, because this case has already been in default judgment since the date of March 7, 2024, and I yield.
All right, so that we know that the review of the court's file, I've heard everything that the defendant has said. Court's review of the file, that none of the requests to adjourn were at the request of the people. It was always at the request of the defense in terms of any delay in these proceedings. Secondly, I do not need a response from the people. If I consider that a motion to dismiss, that motion to dismiss is denied. Where do we need to go now, Mr. Overwater?
Just be asking for an adjournment of the probable cause conference.
Any objection from the people?
No, Your Honor, I have offered a misdemeanor offer of 1 count of attempt resisting obstructing the police. I'll leave that offer open to the next CCC.
September 19th, 2024, 9 a.m. In this matter, thank you.
Thank you, Your Honor.
And if I can take the letter back.
Mr. McCurry, did you have any objections, sir, to the media request? You indicated that you did, that you had an objection, and the court indicated that its tentative was to grant the request for media coverage. Did you wish to put that on the record or no?
Yes, I mean, I'd like to put it on the record, only because I have other children than my 18-year-old son, which this matter is involving.
Okay, but only as it relates to the media request.
Oh, I just wanted to make sure that my other children weren't in the media if I mention their names or if it comes up in if it comes up in the proceedings.
Okay, thank you. And so the court finds good cause to grant the media coverage. The media coverage was granted as relates to ABC 10 News, and the court authorizes the sharing of media news feeds with other media outlets. So that is authorized. Upon further review of this case, the court finds that Mr. McCurry was before the court on October 7th, 2025. At that point, his request for self-representation was granted. However, the court finds that his acknowledgement of advice of rights regarding extradition was not signed. Sir, prior to representing yourself, were you advised of your rights regarding extradition?
All I know is that I was supposed to be on a 72-hour hold, and
Sir, my question to you is, were you advised of your rights regarding extradition?
no, Your Honor, I was not.
The court advises you as follows. The defendant in this matter has been advised of the following rights. The right to require the issuance and service of a warrant of extradition by the governor of the state of California before he can return to the state demanding his extradition. The right to have a qualified lawyer represent him in the proceedings in this state at all stages of the proceedings, and that said attorney may be the defendant's own choosing or shall be court appointed if the defendant is unable to afford counsel. When a warrant is issued by the governor of the state of California and served on the defendant has the right to test the legality of such warrant by a writ of habeas corpus and has the right to a reasonable time after the service of said warrant in which to apply for the writ of habeas corpus. The court finds that the defendant has been advised of his rights regarding extradition on the record in open court on October 15th, 2025. As relates to the complaint, sir, are you prepared to go forward with your arraignment?
Yes, Your Honor.
Please do so.
I wanted to call attention to the emergency motion that I filed. Based on the fact that the 50th District has completely continued to violate all of my rights, my 4th, my 5th, my 14th Amendment, my right to due process is constantly trampled. And I've figured out why, because under due process clause of the 14th Amendment, personal judgment is void if rendered by the court, which has no jurisdiction over the defendant. That's Penmore versus Neff, 95 U.S. 714, 24L, ED 565. And Michigan has no jurisdiction. Before we proceed, we need to establish jurisdiction. It's imperative that we establish jurisdiction.
People?
Your Honor, the people would argue that this motion is not relevant to the proceedings before the court, that it is now time to either admit guilt or not guilt as to the fugitive complaint that the people have filed.
Okay, thank you. Sir, did you care to respond before the court rules on your motion?
There's no injured party, Your Honor. Oh, I'd like to also say I'm here in special appearance.
Specially appearing for who?
I'm here on special appearance.
Sir, who are you specially appearing for?
I'm specially appearing for Darius McCrary. I'm here pro per special appearance.
And when you say you were here pro per and special appearance, who are you?
I'm an authorized signatory thereof of the estate and the executor of the estate.
Who's the state?
The McCrary estate.
And your name is?
I'm Darius. I'm the authorized signatory thereof, Darius McCrary.
And your name is?
Darius McCrary.
Okay, thank you. Anything else as it relates to your motion?
I would also like to add that there's been as far as corpus delicti is concerned, I wanted to know who's the injured party.
The court finds that the issue before this court is the issue of extradition. This court is not the demanding state where many of these issues raised by the defendant may be relevant. This court is tasked with ensuring that the defendant is returned to the demanding state. That will happen either one or two ways. He will waive extradition or he will plead not guilty to the complaint regarding extradition, at which time a governor's warrant will be provided to the court at a later date. Those are the things that this court is tasked with deciding at this point in time. If you have any issues regarding the charges pending against you in the demanding state, then you may raise those in the demanding state. The thing before the court today is the extradition and the extradition only. As it relates to the extradition, is there anything else?
Well, Your Honor, is it possible that we could discuss a bail?
Bail arguments are heard after the entering of a plea has taken place. Again, as it relates to the extradition, are you prepared to proceed?
Yes, Your Honor.
Please do.
Meaning?
You're here for an arraignment. You were granted the right to represent yourself. When you made that request, you indicated that you would have the ability, the knowledge, the education to represent yourself in these proceedings. That request was granted. You were advised that you would not receive any special treatment as a pro se litigant, that you would be treated the same as an attorney. You are here for an arraignment on the complaint. Please arraign yourself.
Well, I'm asking, can we discuss bail, Your Honor?
And I have told you that the discussion of bail arguments are conducted after the entering of the plea.
Okay, Your Honor. So I guess I'm playing. What is it? No. I really.
Do you understand the legal proceedings pending before you?
I do, Your Honor. I do, but I wasn't.
So then please proceed with the arraignment.
So I wasn't here. I wasn't aware that we were here to contract today.
Okay, thank you. The court has attempted to conduct the arraignment with Mr. McCrary, and it is evident to the court that he is unable to understand and appreciate the legalities of these proceedings. As such, the court finds good cause to revoke his pro per status. The court appoints the office of the primary public defender's office to represent him. This matter is trailed.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
Your Honor, calling number 105, Turner, resident custody taken. Custody take lead.
Good morning, Your Honor. Vanessa Duval, Deputy District Attorney for the People.
Julie Gibson, Office of the Public Defender, on behalf of Mr. Darius McCrary, who is present in custody. Your Honor, we are here for arraignment on the complaint. He's been advised of his constitutional rights, previously signed the acknowledgement. We are entering pleas of not guilty, denial to any and all allegations, asking for appointment of the primary public defender's office, and would like to be heard with regard to his custodial status.
Okay, thank you. Thank you, and just for the record, the defendant did not sign the advisor of rights regarding extradition. Previously, the court went over those advisors with him in open court today on the record.
Thank you.
The court appoints the office of the primary public defender's office to represent him. Mr. McCrary's true name and date of birth appear on the fugitive complaint. He was advised of his rights regarding extradition. He waives further reading of the charges. The court enters his not guilty pleas to the charges and his denial of the allegations. The court has appointed the primary public defender's office to represent him. As relates to dates, the court will set this matter in 30 days for the governor's warrant, and that date is?
That date would be November 14, 2025 at 8:30, Department 101.
All right, thank you. As it relates to bail, the Iowa counsel wish to be heard.
Yes, Your Honor. Yes, Your Honor.
Please proceed, Ms. Gibson.
My argument has, I would ask that Ms. Duvall be heard first. My understanding is she's going to make argument, and I don't have all the facts as to why it should be no bail, and I would ask for her to make those arguments first.
Okay, thank you. Ms. Duvall?
Yes, Your Honor. The fugitive is before the court today for absconding or forfeiting bond on a non-payment of child support case out of Michigan. Clearly, Mr. McCrary is not attending to his family matters. He has 2 daughters and 1 son, and this matter is regarding 1 daughter who lives in Michigan. He has previously been ordered to pay child support. As of August 20th of last year, he owed $75,473.26. He owes substantially more at this time. However, Michigan could not give me a figure due to privacy reasons. The defendant has been arrested twice in the past on these same charges, in 2015 and 2023. In 2004, he's been arrested for disturbing the peace. Back in 2023, the fugitive had to be extradited from Los Angeles for these very same charges. The defendant was arrested coming back from Mexico. According to his agent, he was looking at buying real estate down there. He lists his current address as Woodland Hills, which is not in the county of San Diego, but in the county of Los Angeles. He has no ties to San Diego or Michigan. When he left Michigan, he actually had what they describe as a TETR, which is electronic monitoring, when he left the state of Michigan. For all those reasons, the people would argue that he is a flight risk. He's failed to take care of his obligations back in Michigan. We'd be asking for no bail in this matter.
Thank you. Ms. Gibson?
Your Honor, we are asking the court to set bail in the amount of $50,000, an amount for which he can afford. He made multiple court appearances on this case. There was the last time that apparently there was a notifying letter that was sent. They sent it, the district attorney's office in that state had both his email address, his phone number, as well as his counsel's email address, and they chose to send a notifying letter to a P.O. box that was not monitored by him often. And so with regard to the issue of coming across the border, he was across the border working with a group to build homes in Tijuana. There was nothing nefarious about what he was doing. We're asking the court, again, since there are no failures to appear that he has other than that demanding state, we're asking the court to set bail in the amount of $50,000, an amount for which he can afford, and he will make his court appearances. I've already talked to people that are here on his behalf, that are part of his team and represent that he will be returning to the demanding state. He is ill right now, and so I apologize to the court that it's taken a while to have the conversation, but he is adamant. He is a renowned figure. Everyone knows, that's why there are media here on his behalf, that he's going to appear in court. And I understand what the district attorney is saying with regard to prior incidents, but if they wanted him to appear in court, they had multiple ways to get him, and he did not know of the appearance date. So we're asking the court not to release him on OR, but to set bail in a reasonable amount that is $50,000 for him to make his court appearances.
Okay, thank you. Both counsel submit?
Yes, Your Honor.
Yes, Your Honor.
Thank you. The court has considered the arguments of both counsel here today, and the court finds as follows. The court finds that the defendant has previously been extradited, that he was arrested coming back from another country. It has been represented to the court that he has no ties with the demanded state, and most notably that he was on bond previously and absconded. Based upon those factors and findings, the court finds that the defendant is a flight risk, denies his request to set bail. He'll continue to be held without bail.
Your Honor,
And that is the order of the court.
I apologize. Thank you, Your Honor. At this time, after having previous discussions with Mr. McCrary, he is prepared to admit identity, I think he has, and to waive extradition.
He has not admitted identity.
Your Honor, he does admit identity, and he is asking the court to allow him to sign the extradition paperwork, and so we're getting some now. I did not have them. I'm not sure where they are from before, but that is our request to the court.
Okay, thank you. Sir, are you Mr. Darius McCrary?
Yeah, I'm Darius McCurry, yeah.
Okay, thank you. The court confirms the identity of Mr. McCrary as he's identified himself as Darius McCrary.
Yes.
Can we also get an audit?
Hold on.
You sure?
Your Honor, I apologize. It's going to take me a moment to complete these. How would the court like to proceed? Does the court mind waiting while I fill out these forms? They're blank.
Court's in a brief recess.
Thank you, Your Honor. Sir, I don't know what an audit is.
Ms. Gibson, you prepared to proceed?
Yes, Your Honor.
Okay, thank you. We're back on the record. The court is in receipt of the signed acknowledgement of advisement of rights regarding extradition signed by the defendant. The court is in receipt of a signed waiver of extradition to the state of Michigan signed by the defendant, and the court finds a valid waiver of extradition to the state of Michigan, signs the waiver of extradition. As such, this defendant is remanded to the custody of the sheriff without bail, and the court sets a 30-day date review hearing in this date, and that date is
November 14, 2025 at 8:30, Department 101.
Okay, thank you. People, given that the defendant has waived extradition, what is your request as it relates to the fugitive complaint?
People move to dismiss it, Your Honor.
That matter is, that request is granted. That matter is dismissed. Thank you both.
Thank you,
Your
Your
Honor,
Honor.
would the court do a medical referral? He is quite sick.
The court grants the request and authorizes a medical referral for the defendant. That concludes this matter. Thank you both.
Thank you, Your
You're
Honor.
welcome. Thank you, Your Honor.
Thank you.
Your Honor, that concludes the morning's calendar.
Thank you. Court is in recess.
Your name, sir?
Raymond Terrell.
Okay, come on, Mr. Reed. I have you stand right here in front of this seat, okay?
Calling case 2359278, people of the state of Michigan versus Raymond Terrell Blandy. Defendant is charged in count 1 with, where is the information?
Count 1, weapons carrying concealed. Appearance for the record, please. Agent Lewis for the people, P85520.
And it looks like the defendant has not been assigned an attorney. What's your name for the record, sir?
Raymond Terrell.
It's Raymond Terrell. So it looks like you got Raymond Terrell is your last name?
No, it's not.
What's your last name?
You asked me to name on my birth certificate? Name on my birth certificate is Franklin Terrell Blandon. But it would be fraud for me to use that name. That name is copyrighted by the Queen. How could I possibly use that name?
Copyrighted by the Queen. What
Yes.
Queen? You don't have a
Queen
Queen.
of England or whoever, but it's copyrighted. It's owned by someone else. I don't own my name.
In any event, this matter is scheduled for preliminary examination. Sir, you don't have an attorney present here. The court wishes to assign you an attorney.
I'll deny it. I don't want it.
Why not?
I don't want an attorney. I don't need an attorney.
Think you're capable of representing yourself?
Yes, I am.
Are you an attorney?
No, I'm not an attorney.
How far did you go in school?
I went far enough.
How far is that?
12th grade.
Graduated?
No, I did not. I can read, write, and I understand proper English. So,
All right, let me make sure that you understand me. I think that you're really doing a disservice to yourself by not having an attorney. And this is for your own protection because you're not charged with the most serious of crimes, but yet it still is a 5-year felony. You understand that?
yeah, I understand.
Okay. Do you understand that an attorney would be able to do some things on your behalf, like quite possibly get you diversion, to which you would plead guilty, do a short term of probation, and then the case would be dismissed off the record.
I understand my rights and I understand the situation that's going on. So if I would represent myself, whatever happens is what happens.
You understand that if you represent yourself, I gotta hold you to the same standard as if you were an attorney. I'm not cutting you any breaks because you don't know the law.
That's fine. I understand.
So it's your wish to represent yourself.
Yeah.
All right. Now, in no way mean to insult you in any kind of way. But you have heard of that old saying that anyone who represents himself has a fool for a client. There's a lot of truth to it. A lot of truth to that.
It's my right to represent myself, and I wish to represent myself.
Okay. Are the people ready to proceed?
Yes, sir.
How many witnesses?
Just the one.
They call you witness.
At this time, the people call Officer Bashby.
Sit down, sir.
Your Honor, may I ask for a mutual lease restoration with the exception of the officer in charge? Please take care.
All right. Take care, please. All right, ladies and gentlemen out there in YouTube land, if you are a witness or potential witness, I'm ordering you to log off at this time. Sir, please step forward, give your name and spelling to the court reporter. Yes, Your Honor.
Last name B-A-J-P-A-I.
That's awesome.
Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor, I do.
Thank you, sir. Please have a seat with witness box next to me. Voice up nice and loud and speak to that microphone. To the right.
Yes, sir.
You may begin when you're ready.
Can you please take your name and occupation for the record?
Officer Naveed Bashby, police officer with the Detroit Police Department.
And how long have you been a police officer?
Approximately 5 years.
And were you working in the capacity of a police officer on October 5th, 2023?
Yes, ma'am, I was.
Okay, and were you working by yourself?
No, ma'am, I was working with 2 partners,
What's their name?
Officer Ryan Ruloff and Officer Daniel Colgrove.
And on this particular day, were you working in full or modified uniform?
I was working in a modified uniform, as you see me in court today with.
Okay. And were you on foot patrol or in a scout car?
In a scout car.
Was that scout car police marked or semi-marked?
It was semi-marked.
Okay, and when a police vehicle was semi-marked, what exactly identified that as being a police vehicle?
It's present with decals stating Detroit Police on both sides. However, the light bar is inside the vehicle as opposed to on top.
Okay. And did your duties as a police officer take you to 1200 East 7 Mile Road?
Yes, ma'am, they did.
And is that in the city of Detroit, County of Wayne?
Yes, ma'am, it is.
And what is at that location?
That is a Bolero gas station.
Okay. And why were you at that location?
We were conducting a routine patrol in the area.
Okay. And while you were conducting routine patrol in the area, did you observe anything that caught your attention?
I did, yes.
What did you observe?
As my partner pulled the scout car eastbound through the parking lot of the Bolero gas station, I observed the defendant, Mr. Blanding, walking westbound to the parking lot of the gas station towards our honor scalper.
Okay, and can you please point to an identifier on the book code of the person you had identified that you observed?
That would be Mr. Blanding with the gray t-shirt.
Your Honor, may the record reflect that the witness has identified the defendant?
So no.
Okay, and upon making this observation, did you observe anything further?
I did, yes.
What did you observe?
As Mr. Blanding was walking towards us in mentioned manner, I observed the grip of a handgun protruding from his front waistband.
Okay. And based on your observations, what, if anything, did you do?
At that time, I exited my scout car to further an investigation for possible CCW.
Okay, and what happened next?
I made contact with Mr. Blanding in the parking lot. At that time, I asked him if he could present me with a CPL.
And did he present you with the CPL?
He stated to me that he's open carrying and therefore did not need one.
Okay, and upon receiving that information, what did you do next?
I instructed Mr. Blanding to place his hands upon his head in order to safely recover the firearm, which he did.
Okay, and why did you instruct him to do so?
Mr. Blanding had previously informed me that he did not have a CPL, which would be a requirement to carry a firearm in mentioned manner.
Okay, and when you say in mentioned manner, please explain to the court what do you mean by that?
The majority of the firearm was concealed within his front waistband. The only exposed part of the firearm was the grip.
Okay, and did he comply with putting his hands up and everything?
Yes, ma'am, he did.
Okay, and did the defendant have a CPL?
No, he did not.
And did you verify that?
Yes, it was verified via lien.
Okay, and what did you do with the firearm?
I secured the firearm as well as the inside the waistband holster inside my scout car, pending processing of the prison.
Okay, did you place that on him?
I did, yes.
No further question.
Cross-examine. You get to ask questions. Yes. Step to the podium so we can hear you. Right.
I asked you, what was the reason for stopping? What was the reason for stopping?
As I stated, I observed you concealing a firearm in the front waistband.
You observed me concealing a firearm. You can see the firearm properly from which your eye from the scout car from 30 to 40 feet away, right?
As I mentioned, I could see the grip of the firearm protruding from your waistband.
Okay,
Yes.
so how could you consider that concealed if you can see the firearm with your eyes? And that's what the only thing that made you stop me was the vision of my firearm, right?
A portion of the firearm.
No, all you seen, but why else did you stop me? There was no other reason for you to stop me, so that would be considered a Terry stop, right?
As I mentioned, that was the reason for the investigation, the further weapons offense investigation.
But there was no, I was not committing a crime. There was nothing that you can say that I was committing a crime, or no other reason that you can say that I was doing anything wrong for you to stop. So you had, what would you say? You just had a feeling that I didn't have a CCW, so that is the reason why you stopped me.
No, sir, I had reason to investigate you and ask you to present your CPL card.
But what was the reason for stopping me? I was not committing a crime. I was walking through the stairs. You can see the gun. You don't know if I have a CPL or not. So what gives you the right to even stop me in the first place in question?
Because the majority of the firearm was concealed inside your waistband.
Once again, you don't know if I have a CPL or not, right? So why did you stop me? You don't know if I have a CPL or not. I'm not committing a crime. I'm walking down the street, so you have no right to stop me and question me in the first place. That is a violation of my statement.
Yeah.
Is that a question or a statement?
So
you have to ask questions.
So you can see that I was not committing any crime. So can you tell me what was the reason for stopping me besides the sight of my firearm?
That's been asked and answered.
Okay, so there was no other reason for you to stop me. I don't have any more questions.
Okay. Any redirect?
No redirect, Your Honor.
Thank you, sir. You missed it.
Thank you, Your Honor.
Any other witnesses?
No further witnesses, Your Honor.
Sir, do you have any witnesses to call?
No, I don't.
Your Honor, at this time, the people will request that the case be bound over. We do believe that this is a question of fact for the trier of that to be here from the witness officer that time he stated upon observing the defendant with a grip of a handgun protruding from his waistband. He then went and investigated for possible carrying a concealed weapon, upon which he asked if he had a CPL. The defendant did not present one, at which point the officer recovered the handgun and made it safe, and also verified via need as to whether he had a a license to carry, and which he did not. So Your Honor, the people who believe that this question of fact or trier fact based on that.
Mr. Terrell or Mr. Landon, whichever the name is, would you like to make an argument as to why the court shouldn't bind it over?
You say what?
Would you like to make an argument as to why the court should not bind this matter over?
Yes, I would.
Go ahead.
Because he violated my Second Amendment rights. I have a right to bear arms, and I was doing nothing wrong. I did not commit a crime. He did not have a reason to stop me in the first place. That would be considered a Terry stop because he didn't have a reason or a right to stop me. I was not committed a crime. So why did he even stop me and approach me? I have a right to bear arms. My arm was legal. It's registered. So therefore, why was he even stopping me? That's harassment. He stopped me because he seen a black man carrying a firearm walking out of the store. There was no other reason in the world he could stop me. I don't see no other reason why he could stop me. Like, I was not committing a crime. Usually, you would have to be committing a crime for someone to stop you if you're walking out the store. Well, the only thing he's seen my pistol. I have a right to carry a pistol. That is my Second Amendment right. So why is he stopping me?
All right, I get what you're saying, and that's not different than an argument that an attorney would make. You didn't do too bad, especially to not have any formal education in law or college and life. But let me explain something to you. You do have a Second Amendment right to bear arms, but as all of your rights, none of those rights are absolute. States have been made to regulate how and when you can carry a weapon. In the state of Michigan, although you can open carry, you cannot carry a concealed weapon. Sir, hold on, let me talk. You cannot carry a concealed weapon on your person without a license to do so. Sir, please do not interrupt. Let me talk. I'll give you another opportunity, okay? All right. So the officer testified that the weapon was concealed on your person. It wasn't totally concealed in that he could see the hand grip of the weapon. It does not have to be totally concealed in order to be concealed in the state of Michigan. A portion of it, he said that the only part that was visible was the grip of the handgun. That would be considered concealed, or at least a question of fact as to whether or not you were open carrying or carrying a concealed weapon.
The only thing that I can say that would be the problem is I had the Empower holster. I wasn't aware of the holster.
Your holster is an even issue. Yeah. I don't have a problem with you having a holster. I don't have a problem with you carrying a gun if you're open carrying.
Yeah, open carrying. But the reason he seen the gun, Your Honor, is that's the only reason he seen it. When I walked out of the gas station, he can see it with full view. How can you consider that concealed? That is out for him to see.
Because a portion of the weapon was concealed. You can see that the portion of it was concealed. You had an inner holster, right?
Yes.
So with the inner holster, because I carry one myself, with the inner holster.
Like a quarter of the gun is concealed and the rest of it is hanging out.
Well, I don't know what kind of gun it is, but a quarter of a gun or half the gun, he said that most of the gun was concealed.
The majority of the gun was out there. If you can see the video from it, you can see the gun and you can see how much of the gun was hanging out from the video.
All right. So you'll be free to argue that even if this gets to trial, that the gun was not concealed. But based on his testimony, his sworn testimony, he said that the majority of the gun was concealed. The only thing that you could see was the handle of the gun, and that's what he observed. Now, possessing the gun on your person gave him reasonable suspicion that you might be carrying the gun without a license. And that's what he acted on. He went in to further investigate whether or not you had a CPL.
That was like a hunch, though. That's like he couldn't say for sure.
That's what reasonable suspicion is.
A hunch, and that gives you the reason to stop me. If you don't know how I'm committing a crime, for sure you shouldn't be able to stop me.
Reasonable
Maybe.
Reasonable suspicion. You mentioned the case Terry versus Ohio. You might want to go read. Reasonable suspicion means that you have reason to believe that criminal activity might be afoot, and that you can articulate on the record what that reasonable suspicion is. He saw you with a gun that was somewhat exposed on your person. Based on that, he could come and ask you questions to see if you were carrying that gun legally or not. Based on his testimony, he did so and you were not. So that's where you stand. All right. So the court, after hearing the testimony of the officer, is satisfied the people have met their burden of probable cause as it relates to the charges contained in the complaint warrant. The court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this defendant committed. The defendant will be bound over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information, date, and time will be February 15th, 2024 at 9:00 a.m. Bond will be continued.
All right, are we ready on Ms. Lee?
We're ready, Judge. She's going to avail herself to the offer of the people.
Well, before we go on the record, what is that all?
A drag racing and a disorderly, and then the rest will be dismissed.
This is the city of Detroit versus Lakeisha Lee, case number SP 171-6956, counts 1, 2, and 3. SP 171-71811, appearance for the record, please.
Good morning, may it please the Honorable Court, Tatanisha Reed on behalf of Lakeisha Lee, who is present via Zoom.
Ms. Lee, good morning to you. State your name for the record, please.
Good morning, Your Honor. Lakeisha Lee.
Day, date, and time set for a trial is Officer Jackson here. He was.
I think he might be in the breakout room.
I'll pull him out. All right. Ms. Lee, my understanding, you want to avail yourself to the offer?
Yes.
All right, raise your right hand, please. Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes.
Put your hand down. Officer Jackson, good morning to you. Can you put your appearance on the record, please?
Yes, Officer Jackson, badge number 3919, out of the 12th precinct.
All right.
He got an alternate camera, Judge.
You got some pants on, officer?
Sir, they're in the. No, sir.
Officer Jackson, okay, Ms. Lee, it's the officer's as charged as a disorderly person, correct?
Yes.
And then amended count of drag racing?
Yes.
All right, you want to take the deal, ma'am?
Yes, sir.
Can you raise your right hand, please? I mean, I already did that. You understand one possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes.
You understand that you have an absolute right to a trial?
Yes, sir.
Ms. Reed, I went over your other advice and rights in breakout room, did she not?
Yes, she did.
Understood those rights?
Yes.
You have any questions about those rights?
No, sir.
You know, by taking the deal, you're going to give those rights up?
Yes, sir.
Has anybody offered you anything other than what's been stated in the record?
No, sir.
Draw your attention back to May the 5th, 2025 at around 10:07 p.m. City of Detroit in the area of McNichols and Ward. Did you have contact with the Detroit Police Department on that day and that time?
Yes, sir.
You operating this motor vehicle?
Say that again?
Were you operating this motor vehicle?
Yes.
All right, Ms. Reed, I don't have any notes on here to tell me what the reckless driving and disorderly person, was the disorderly person on the same date?
Yes, may I voir dire?
You may.
Ms. Lee, on that date and time, were you a disorderly person, i.e. maybe talking loudly, unruly, in the presence of others and officers?
Yes, ma'am.
Okay. And as for the drag racing, were you operating a vehicle on the road in a hazardous manner?
Yes.
And how were you operating that vehicle?
I was driving.
I know, but speeding?
Speeding.
He say I was speeding.
Lakeisha, were you speeding?
Yes.
Well, no. He said you were speeding. What do you say?
I was speeding, but I wasn't drag racing speeding. That's what I said.
But drag racing is your plea. Hold on, Judge. I'm
I
sorry.
got this. Let's get to understanding. You were speeding, right?
Yes.
Okay. What else did you do besides just speeding?
I was disorderly.
No, were you weaving in and out of traffic?
No, I don't recall. No.
Did you not use? Go ahead.
I was speeding. That's it. I was going over the speed limit.
And Your Honor, I think that's a factual basis for drag racing.
I don't know if that's the factual basis for drag racing. I would not think that would be the factual basis for drag racing. Just speeding. Drag racing, you have to be racing somebody. She didn't say she was racing.
But as you know, Your Honor, with this being a plea, she was originally reckless driving. So were you driving when you were because we're doing a reduced count to drag racing, were you driving your car in a reckless manner? Your Honor, she had said yes when I first asked her that. Were you driving your car in a reckless manner, Nikisha?
No, I was speeding. I was not driving reckless. I was speeding. I was just going over the speed limit. That's it.
Right. So if that is the case, where do we get reckless driving from? And it's never been totally defined as far as this court understands, reckless driving being a full wanton disregard for people's safety.
I think maybe if she was going so much over the speed limit, so many miles over the speed limit, it could be considered reckless because you're putting other people's lives in danger. May I ask the officer that question, Judge, if that'll help?
Can I participate?
Stop, please. Let me ask her what, because this is all about her plea. Now, I know the officer may say one thing and she may say another, but this is all about her admitting responsibility to what she says she did. Now, how fast were you going, Miss Lee?
I believe I was going 65 miles per hour.
In what zone?
In a 45.
No, there's no 45 on West McNichols. There's not a 45 on. You were going 65 miles an hour in a 30 or 35 mile an hour zone at the most. All right, I'm going to find that to be very, very excessive. So I'll find her guilty of the amended count of drag racing. With stipulation of probable cause, we'll dismiss the other two matters.
So stipulated.
You need to take a driving course too, because if you think that you can go 45 miles an hour down, if you think that the speed limit on West McNichols or Ward, whatever street that was, we know it's not 45 miles an hour on Ward, but if you think the speed limit is 45 miles an hour on West McNichols, then you need to take a driving course, because automatically on those streets is either 30 or 35. All right. I'm going to fine you $240 and $240. When can you pay?
What is it? $240? 2 tickets?
2 tickets, so 480.
480. Can I get 30 days?
Yes. Is this any delayed sentence at all?
Tamika Horn on behalf of the city, no, Your Honor, it's as charged.
All right, Miss, I'll even mark allowed payment plan. So Miss Lee, has it any div that kiosk in the city of Detroit? I'm told you can upload the div that app to your phone, or you can come on down to the courthouse and pay it in person, or come down before or on December 1st and pay it and get into a payment plan, man.
Yeah, give me December 1st. And I can get into the payment plan when I come inside?
Yes, you should get into the payment plan when you come inside and when you come down to the courthouse. I think you're gonna need to bring at least 20% down, all right?
Okay, yes, sir, thank you.
All right, if there's nothing further, have a very good day. and best of luck to you. All right, Ms. Reed, thank you very much, and you be safe as well.
Thank you, Judge, and thank you, Sister Counsel.
Yes, yes, ma'am. Thank you. Thank you, Judge.
Thank you.
Okay, officer.
I'm not threatening you. Say one more word and that's 30 days. 30 days.